I am going to whiz through this presentation because I want to get to the speakers, but I feel it's necessary to situate us in Florida. We've done a lot of national discussions today, and this one is particular to Florida, though it applies nationwide. So those who have not practiced in juvenile justice on juvenile justice issues may be able to follow, though I'm not predicting that you will be an expert. We have 3 types of transfers: waiver, indictment, and then 99% of the transfers in Florida are direct file, which is the topic of this panel. Oops, wrong way. We also have 3 types of direct file: discretionary direct file with the ages there, and they may be sentenced as juveniles or as adults. We have mandatory direct file with discretion, though it's considered mandatory direct file. The state attorney can decide not to prosecute as an adult, and then we have mandatory direct file. And those are the criteria, the age groups, and this will be available on the website for CLE material. When I say direct file, just more broadly, it's the decision to try a child who has the assumption of being a child in juvenile court, transferring them up to adult court. In Florida, it's mandatory that children who are transferred to adult court must be housed in adult jails. There's no discretion by the judge, and there's no discretion for reversal back to bring the child back to juvenile court. In some states, there is that judicial discretion. This is Florida by the numbers. Florida is the number one state in use of direct file. We've steadily been going down in the past 5 years. Comparison by circuit. We have 20 circuits. The circuit that we're in now is the 13th Circuit, which just encompasses Hillsborough. And we are number 4, we being Hillsborough. Hillsborough in more detail, the numbers have been dramatic in the past 5 years in reduction. The reason why I compare Hillsborough to Dade is that their adult transfer numbers are the same, but Hillsborough has almost half as many youth population as Dade. So they're transferring more children per child compared to the amount of youth that are in Dade County. These are just a little more pictures on Florida versus Hillsborough in terms of age. So Hillsborough direct files more children under 15 and 16, 13 and 14 than the state average. And race and ethnicity, which is something that was discussed in the previous panel. Hillsborough direct files more children of color than the state average. We will now go to the panelists who will have 2 to 3 minutes just so that we can talk more as a group. They will introduce themselves and explain their reference points on this issue. First, we'll start off with Andrew Warren, the state attorney for the 13th Circuit.
Hi, good morning, everyone. So I was asked to talk about direct filing, obviously, but I thought it was helpful to give a little bit of a backdrop of what we're doing in the state attorney's office with respect to juvenile justice. And I'm a strong believer in criminal justice reform, and at the heart of criminal justice reform is the idea that prosecutors have to focus on the long-term consequences of what we do in the system. How do we make the community safer in the long run? How do we reduce crime and recidivism in the long run? And what's the impact of conviction and incarceration on an individual, on that person's family, and even on an entire community? So what we're trying to do to embrace that vision is starting with the idea that there are different types of offenders that come into the system. And this is an undeniable fact. So we have people who pose a threat to the community, the people who are violent criminals and serious fraudsters and serial recidivists. And against that, we have people who get into the system for often other reasons. They suffer from substance abuse or mental health problems, or they get caught up in poverty traps. And we have to treat those different types of offenders differently because the long-term needs are different to promote the goals of community safety. No arena of the law tests these principles like juvenile justice. I mean, how we respond to juveniles and how we treat them in the system to promote the best long-term impact for the community is a very difficult question. Now, locally, we have really good opportunity because we have a public defender and law enforcement and the state attorney who are all on the same page in terms of the evolution of criminal justice, the fact that we need to do things differently than the way we've always done them. At the state attorney's office, we've been focusing on 4 different things with regard to juvenile justice. The first is that we've created a comprehensive civil citation program, so that's pre-arrest, to keep kids out of the system before they even get involved in it. We're expanding the use of diversion programs for kids once they get into the system. We're looking to create new diversion programs, such as juvenile mentorship and mental health programs. And last, what we're talking about today is how we charge cases, especially with regard to direct files. So it's Juvenile Justice 101 that direct filing should be reserved for the most serious juvenile offenders. You have think tanks on both the left and right side of the political spectrum that have concluded, and independent studies corroborate this, that overcharging juveniles and putting them into the adult system reduces public safety, it increases recidivism, and it's extremely costly for the community. So over the past year, we've been able to make great strides in the state attorney's office in reducing the number of direct files, and I think we'll be able to talk about that later. But we're not flying the mission accomplished banner just yet. We know that the reduction in direct files is just one part of what needs to be done in the system to reform our juvenile justice system across the state of Florida.
Thank you. Next, we have Julie Holt, the public defender for the 13th Judicial Circuit.
Good afternoon, everyone. I just finished my 25th year as the public defender here in Hillsborough County, so I wanted to kind of lay that out for you a little bit so that you'll understand where I might be coming from as it relates to my position. And one of the things I'd like to do is recognize Judge Ralph Stoddard that is sitting here. Judge, wave just so that everybody knows who you are. And the reason I'm doing that is because Judge Stoddard was tremendously influential a few years ago in bringing attention, in particularly to this issue of juvenile direct files here in our jurisdiction, because obviously you've seen the slides and you know what the numbers look like. And as the public defender by yourself here in this county, you can't do anything. But when you have a judge that takes a tremendous interest in children, takes a tremendous interest in how these children are being treated in the dependency system, as well as the delinquency system, as well as the adult criminal justice system, that's where you actually start to see things change. And that had a lot to do, bringing a lot of people together through Judge Stoddard. And then obviously also Rosemary Armstrong, who's going to be talking to you here for a few minutes. Those individuals helped us move forward the thought process that something was wrong in Hillsborough County. My first position is you should abolish juvenile direct files. That's across the board. I just don't think it should exist. I think children should be treated differently and addressed differently. And although I understand that sometimes children are involved in tremendously violent types of situations, I still believe that we can create a system where children are not placed into the adult system. Juvenile reform, which is where we're ultimately going to land here today, needs to really recognize the failures of what the juvenile direct file system has done. And there was a legislative reaction to some crimes that were occurring, primarily down in South Florida, that resulted in this significant change. But for us, the things that we've been able to do in the office is divert some of the lawyers in our office to actually do pre-file advocacy work. So I was able to hire lawyers to do that type of work where they could actually case by case sit down with the state attorney's office and say, this is why this child should not go into the system. That's very labor intensive, especially when you have the number of children that we had that were being looked at for juvenile direct files. We had up to 1,000 kids that were being looked at. So that was really difficult to do. But it was something that we needed to do to show that a change could be made. I'm very fortunate now that the state attorney affords us an opportunity to address each and every single case that is eligible with them before the decision-making process is made. So I would tell you that one of the big things is it really does matter who's a judge in your jurisdiction, who's a public defender, who's a state attorney. All of those things really do matter because that is what will ultimately drive the decision-making process and the results, direct and indirect, of the criminal justice system that impact our community. So thank you.
Thank you. Following, we have Rosemary Armstrong, the Executive Director of Crossroads for Florida Kids.
Good afternoon, everybody. Excuse me. In 2012, Crossroads for Florida Kids was founded by myself, my husband Sandy Weinberg, and Allison Singer. My position on direct files is the same as Ms. Holt's. I believe that they should end in Florida and throughout the country. The reasons are because children are different than adults. They're less able to reason logically, they're more impulsive, they are not able to withstand peer pressure and to predict future outcomes of their behavior. They are therefore, in my opinion, and I think others, less culpable than adults who commit the same crime. But because their bodies, personality, and brains are in the process of maturing, they are uniquely suited to the rehabilitative programs in juvenile system. It's counterproductive to direct file children. Recidivism rates for children, prosecutors, adults are higher than those adjudicated in the juvenile system. Direct files disproportionately affect minority children. Common sense tells us direct files are wrong for children and wrong for reducing crimes. I believe we're better than this, and I believe that in light of what's just happened in Parkland, Florida, where no one could have believed there could be changes, legislative changes in gun laws in Florida. I think that it is time. I think that polls show that people want fewer direct files or no direct files. And I think that the fact is that states all over the country are less using direct files or are not having them at all. My perspective, and I'll finish, I haven't gotten 30-second signal yet. My perspective comes from being on the ground level with kids. When we founded this program, it was originally to represent children in foster care. Florida is only one of 10 states that does not provide attorneys for all children in foster care. So that was a pro bono program we started. We now have close to 150 attorneys who are contributing 5,500 pro bono hours a year. Our first case we got in 2012 was from the wonderful Judge Ralph Stoddard, and it was a direct file case. Two of our attorneys, because the public defender conflicted off, handled the criminal side to the dependency side, and she was out. She couldn't post bond. She's in foster care, right? She was out and back in the system and eventually reunified. Since that time, our attorneys have represented 33 children who are direct filed in Hillsborough County, and I was involved in the representation of 27 of those children. Most of the children I represent, I was their dependency attorney for months or years, so I really, really knew them. So when the time came for a direct file, and most of them did come before Andrew Warren was the state attorney, I was able to give mitigation. I also visited those children every week in jail, so I really got to know them very well. I know about their families, I know about their trauma. Most of them were in foster care.
So Rosemary, let's talk about the mitigation of the issues that come in. This previous panel talked about prosecutorial discretion, and direct file is ultimately at the discretion of the prosecutor. So Andrew, can you just start off saying what your office considers when you determine direct file, whether a child should be direct filed, whether there are written policies, who actually is involved in those decisions, and whether law enforcement has a stake, I mean, not a stake, but an influence on your decision?
Before I get there, because this man here is the only honorable one among us. He should.
I mean, just one. I mean, I am the only honorable. No, I'm kidding.
I apologize. So, I want to
I'll
get to the question.
Joke.
So I told him that we're just going to leave him out this whole time. No, lastly, we have the Honorable Sean Shaw, the state representative for in the Florida House of Representatives, who is now running for Attorney General of Florida.
So I'll be really fast. That's a big hint, I guess. Yeah, when the James Madison Institute and the Southern Poverty Law Center agree on something, you should pay attention. And so we all sitting up here, and a lot of us agree that this is an issue. I filed House Bill 509, which would have eliminated mandatory direct file and changes the discretionary prosecution of children as adults. I appreciate the applause because the bill saw no movement. And so I would tell you that while we all, and here in Hillsborough County, we're extremely lucky because we have a state attorney and a public defender and a bench that are progressive on this issue and that are really wonderful. Unfortunately, throughout the state, there are places and jurisdictions that are not that progressive. That is why the legislature needs to address that. I am not hopeful that the legislature will address it in a meaningful way, unfortunately. I hate to be the bearer of bad news, but simply, this is one of those issues where everybody talks a good game, and then when I filed the bill, it literally got not one committee stopped. So that ought to tell you how popular this bill is in the Florida House. In the Senate, it went through 2 committees and passed through 2 committees. So criminal justice reform, particularly when it comes to juveniles, I think is something we all talk about, those of us that are elected, but I think we have a vastly different definition of what true reform is. I'll end with this. The legislature passed a bill, I think, to collect more data and then declared victory. That, to me, is not criminal justice reform. I don't know how much more data you need to collect to know what we need to do as a country and as a state to institute true, meaningful criminal justice reform so that we don't continue this mass incarceration culture that we have here. So that's what I would say. But we all sound good, but unfortunately, when the rubber meets the road, we're not really getting where we need to go, in my opinion. Thanks.
And the bill that was just passed, I believe, doesn't address juvenile justice data collection in the same regard as adult. So we're not even at that point of admitting that we need more data before we can even move forward.
What more data do you need?
And it doesn't even include all of the different attorneys that handle the different types of cases. They only chose state attorneys and public defenders, which leaves out the private bar and everybody else. Well, I was going to say the data collection, what was interesting was there's a tremendous gap in the beginning. They're going to collect data from the state attorneys and the public defenders, but they're leaving out court-appointed attorneys and regional counsel attorneys, which handle, a good number of cases, especially in light of the fact that we do have conflicts that arise because usually in the juvenile area you have co-defendants. And when we brought that to the attention of staff and the sponsors, they just didn't want to listen. And it was really interesting because if you listen to the press conference that existed, it's almost like you already know what the outcome of the data collection is going to be after 3 years. And in 3 years, we will, at least in Hillsborough County, we will have already changed the culture primarily because we've already focused on the things that need to happen. So it just gives you an idea of what the Honorable Representative Sean Shaw is talking about.
I appreciate that.
Andrew, back to what data you consider then. What are the factors?
Sure. So we start with the facts of the case and the seriousness of the offense. I mean, those are the obvious ones. We look at the juvenile's age. We look at their criminal history in terms of whether they have pending cases, recent cases, whether there's been a trajectory of escalation. I'll tell you what we don't look at enough is criminogenic factors. We should be looking at the factors that tend to influence and predict an offender's likelihood of recidivating and escalating. You'd asked about whether we have written policy decisions. We do. We have a written policy about direct filing, but I'll tell you, a written policy can't answer the difficult questions. So I've worked closely with our new juvenile chief, who we installed when I took over. That's what's led to the reduction in the direct files in our office. And having a single person who's making those decisions not only leads to consistency in those decisions, but it ensures that the person's on the same page that I am. I think there was also a question about law enforcement's influence. We rely heavily on law enforcement, but law enforcement's better situated to identify for us the kids who are real threats to the community, the kids who are at risk of escalation that sometimes we just can't see from the paper itself. And law enforcement's better situated to give us the criminogenic factors that we should be considering. But law enforcement's voice is really one piece of information that we collect. They're not dictating how we determine what legal avenue to pursue.
Throwing it out to the panelists, you just heard what Andrew considers in his office. Are there other factors that he should be considering so that this decision is more accurate?
Yes, when a child is in the juvenile system and they're considering a commitment program for the child, there is a staffing held. And at the staffing, There's information from parents, there's information from public defenders, from the state, from law enforcement, from attorneys ad litem who have been representing if their kids in foster care for months or years. And other people come in and give information about the child. So the state attorney, who has absolute discretion, the commitment program manager in DJJ can make a decision. I think taking the time to really have a staffing like this before a decision is made. I understand Mr. Warren said that the public defender's involved. If it's about a foster care kid, they should be talking to me and the attorneys who represent that kid and have represented that kid. Because the kids who have been direct filed in the last 6 years include kids with intellectual disabilities, mental health issues, severe trauma coming into foster care, and not being taken care of and treated, all these problems, substance abuse problems in foster care. So we could bring that out. They would be better treated and rehabilitated if they stayed in the juvenile system. So a staffing would be great. A little more time to do a staffing when there's even a greater loss of liberty than there is in the juvenile system, as it would be if the child is direct filed.
The other thing I wanted to add, and it's building on what Rosemary says, is that what we really need is a much more united data sharing type of information, because when Rosemary's telling you how she knows a child for 6 or 7 years, when we're appointed to a child, there's about a 90-day period that you represent that child in the juvenile justice system. Now, if they're direct filed and they go into the adult system, you're going to get to know them a little bit more and you're going to get access to more information. But the juvenile justice system moves so quickly that that's really problematic. So the first thing is to make sure that Mr. Warren's office does have the information of a dependency child. The other thing that we were talking about, though, is when you take into consideration, if you're going to have policies and you're going to say that law enforcement and or victims of crimes are going to have influence on the decision-making process, the only thing that is problematic with that is that it appears from the studies that what is shown is that then there are arbitrary decisions that are being made based on those individuals' input, as opposed to a much more objective aspect, because there are offices in Florida that if a victim is opposed to a child remaining in the juvenile justice system, then that prosecutor will direct file that child as a result of that. And that lends itself to, obviously, the over minority representation that exists. And so I think you have to be very careful about how you use information that is not more geared towards what this particular offender that you think has done something about that offender, where they come from, what their background is, and what the future hopes are for how that child will change. I think you have to take great direction from the United States Supreme Court in the cases of Graham and Miller. They've identified for us the criteria that should be considered in how you look at and how you evaluate and how you deal with children. So I think that we're missing an opportunity when we don't take that clear-cut criteria that exist, and it's based on, obviously, the studies that were done about how children are different and their brain development and everything else that exists. And if we slowed down the system long enough to take all these things into consideration, because once the decision is made in Hillsborough County, it's shown that the chances of a child being treated as an adult, if they are direct filed, is great. It's high. It's over 70%. And for those children that are put on probation, 50-some-odd% of them are not successful on probation, because it's an adult-based system, not a juvenile system.
I agree. I mean, that's what happens when you go last. I totally agree. The public defender said something about the objective factors. Again, I told you, we're lucky here in Hillsborough County. We have very progressive state attorney and public defender, but in certain places we don't. And, you know, Florida, from the outside looking in, you think Florida's a very progressive state. It is not on these criminal justice matters. It's really in the dark ages and a lot of where we allocate our resources as a state. What, in fact, we believe is important and what we don't. What we will fund and what we don't. We'll lock people up all day. What we won't do is engage in rehabilitation. What we won't engage in is education when they are in these facilities, particularly juvenile. We don't fund that adequately. So all that is kind of a holistic problem we have.
Continuing on with the factors and the things that a state attorney should consider, you had mentioned, Andrew, the conversations with the victim. How much should a victim have an impact on your decision to direct file a child?
Little to none. And they do. I mean, look, I have victims who come in and they want to seek the death penalty. I'm like, all right, you know, your car was broken into. That's not what we do here. So a victim's opinion is important, but the role of the victim is to make sure that we are protecting the victim, providing restitution for the victim, ensuring victims are treated with fairness and dignity throughout the process, but the victims aren't decision makers.
In your conversations with the state attorney, Julie, do you bring along family members, teachers, medical professionals? Who else is in the room, if anyone?
The quick answer to that is no. What we do try to do is we try to give all of that information, though. We do talk about the child's background, about their family, what support exists, what doesn't exist, what program might be of benefit. And one of the things that, if we actually had juvenile justice reform, one of the things that I think is extremely important is that there be judicial waiver hearings, that we have judicial waiver hearings. If we're going to have direct file, you need to have these hearings. And that would put the burden then on the public defender, as well as if Rosemary's involved in the case, it would put the burden on us to bring forward all the information that a judge should take into consideration. If we could have that type of a process, that would work great. I do have the luxury of, with Mr. Warren, as he indicated, by having one contact person in his office, that's who we go to. We do participate in staffings. We have a lawyer that does all of the staffings for us, and we argue not only about whether or not a child should be direct file, but what type of placement there should be, what kind of programs there should be. If we had some good reform, and I'm sure that if I were to send a letter in every single one of the cases that Mr. Warren was considering for direct file, I'm sure that he would take that into consideration. The problem with the juvenile justice system, he's got 21 days. He's got 21 days to make the decision, and in 21 days, we just can't address the way the system is set up right now. We can't address every single eligible direct file case. So that is one of the problems. We really do need the reform.
Is there anybody else who would like to respond to? Okay. I'm going to hold off on the questions until the end of the panel, just so we can get through some of these discussions, but keep them in mind. You will get a chance. Thank you. There's this idea that if a child does an adult crime, they do adult time. But is direct file outmoded given what we know about adolescent brain science? And if so, what process should be instituted in order to help hold the child accountable for the serious crime, but also take into account their immature behavior that they cannot control? Throw that out to anybody who wants to respond first.
I'm going to tell you the system is outdated, not just because of the science, but because the system is outdated. We're just not doing an effective job of providing for long-term safety of the community. And this goes back to, look, I was an intern for the Department of Juvenile Justice 20 years ago when the super predator conversation was going on. And I remember in my little summer job that I was supposed to assess the impact of this legislation. And I did a lot of research back then, and back then the people said this whole tough on crime, lock them up and throw away the key is a myth for low-level and moderate offenders. It works for the most serious offenders. 20 years later, we're still having that same conversation. And it's worth noting that a lot of the people who were the academics behind the super predator philosophy have since recanted what they said 20 years ago that led to this major shift in philosophy that we need to be tough on crime and lock them up, every single person who comes into the system. That is a flawed, outdated, and counterproductive philosophy.
So what process, the second part of the question, what process would you want to see that would be better to treat kids properly? What would the process be?
Well, for the most serious offenders, I think we do need to go through the traditional model of prosecution, conviction, and incarceration, but not in the adult system. The problem we have in Florida is we don't have enough resources for commitment facilities and juvenile detention centers for the kids who need to be placed incarcerated as a juvenile. So we're forced with the most violent offenders to put them into the adult system because we do have to balance the public safety interest. When we have no other option and no other place to put a kid who's 14 years old and has robbed someone at gunpoint 3 times, we are forced into a situation where we're now throwing that kid's life away for the next 60 years because we have no intermediate avenue to address the criminogenic factors for the next 10 years.
Angie's exactly right. When you put a 14-year-old in a facility that's an adult facility, all the data that we already collect, that we don't need a new law to collect, tells you what happens to that child. And so not only that, it is fiscally inefficient the way we do this. It's expensive, and it's more expensive than it needs to be. If we put the resources into having juvenile facilities and doing what we needed to do, it would be a lot less expensive, and the state would save money. I tried to make that argument to my counterparts on the other side. It didn't go far. But the mass incarceration is just unsustainable, not only morally, but fiscally. We cannot continue to build prisons and prisons and prisons. It's just the state can't afford to do it. So ultimately, I think that is what will force us to change how we do these things. But Andrew's right, it's outdated, it's immoral, it's just we need to go ahead and get with the times.
And it doesn't make sense because recidivism is higher if you are in the adult system than juvenile. But I want to point out something because the day in the life of a kid who's in Falkenberg jail in the juvenile pod is a lot of tedium. There's a lot of drama in there. In fact, the kids who turn 18 are very happy to be, they say, in the adult system because there's not as much violence and threats of violence, et cetera. But recently, I had the occasion to go into the lockdown facility for juveniles and even to go back and to talk to a 15-year-old client who was in there. There was a solid opaque door just with an opening for the food to go in. So the way I talked to him was I got down on the floor. There was just a little crack underneath from the door to the floor. His head was then on the other side. It gave me the opportunity, though, to see inside what I would call a concrete closet with a little, small, not very much of a pad to sleep on, a pallet, a toilet, a sink. And lockdown, he was there not because he did anything wrong, but because he's 15 years old, he's slight, and he's been subject to threats and worse in the juvenile pod. He's in solitary confinement for 22 to 23 hours a day, 4 a.m. breakfast, Monday through Thursday. He can't go out for school, so they sometimes, the teachers will bring some workbook sheets to do, 12:30 lunch, afternoon out of the cell for a short time, maybe an hour in rec room or some time outside, all by yourself though right now, 4 p.m. dinner. Nighttime in lockdown, he told me, is noisy. Most juveniles stay up most of the night until 4 a.m. breakfast, then sleep. No games, no one to play with. That's what solitary confinement for juveniles, which of course the ABA 2017 resolution is specifically saying that solitary confinement for under 18 should not happen.
Sean had mentioned the expensive nature of adult and juvenile justice systems. In your opinions, what would you do if you could allocate that money from the criminal justice system and put it into services or put it wherever it needs to go? Where would you put it?
I guess I got to answer that one. I would put it in programs that have a proven track record of either preventing kids from having an interaction with the system in the first place, or putting children that may have had that first interaction, you put them in a program, they will not recidivate. For example, I'll give you one. There's a program called Prodigy Arts Program here in Hillsborough County, and it's an arts program that if it's a child that's had an issue, they go into this program. The data shows that child is almost guaranteed not to have another interaction with the criminal justice system. The legislature thought it was wise to cut that program by $2 million. Like, those sorts of programs are where you should spend the money. They have proven track records rather than just locking them up in adult facilities. And if you have visited an adult jail, prison in Florida, I would tell you, I would invite you to do it if you haven't. It is eye-opening what goes on in there, what services are not available, how bad the facility is maintained, what this state, doesn't provide just in terms of working toilets, working showers. There's classrooms empty because we don't pay enough people to be in there to teach and provide security to the inmates. So there's a classroom sitting there ready for vocational training, but because we don't have enough correctional people, there's not enough security to have a class while the other inmates are not in class. Just that is where resources should be allocated rather than just building, which is what we do in the state, prevention and rehab programs.
It really is about the prevention aspect of it because, and so we know what the demographics are. We already know what communities are most affected by juvenile direct files, for instance, and juvenile crime. So the reality of it is the legislature, when they're looking at programs, either like Prodigy or like Boys and Girls Club or like Pace Center for Girls, those types of projects, that's where you should be putting more and more money in to it. And what I did recently was I was curious. I brought in somebody from the outside to talk to kids for 30 days in the detention center. And all of these, for the most part, the kids were there for the very first or second time in the detention center. And what they said, was, number one, who they hang around with is problematic. Number two, where they live, if they don't have a safe place to go out and play or to hang out or something of that sort, that causes problems for them. And the other thing is they want the ability to have some type of jobs, which when Andrew's talking about the economics of the criminal justice system and how it creates and really causes even more poverty to exist than needs to exist, that's what we should be doing, investing in communities that we know are impacted by these things, giving these children safe places to go after school and even during school, and we should provide them opportunities to have part-time jobs, just like children in South Tampa can do very readily and very easily. Those types of investments do pay off, and more importantly, the kids themselves are telling us that they need these things. We're also not taking into consideration really the developmental challenges that children of today seem to be having. So those developmental challenges are mental challenges that truly exist, and you have to put resources into how individually to address those children so that they can do cognitive behavioral changes. There's got to be cognitive behavioral changes. And any program that doesn't work under that theory is obviously problematic, because that is what all the studies tell you needs to happen. You need to show someone how to change their behavior. And it has to be long-term investment. So it can't be the criminal justice system that does it. It's got to be outside of the criminal justice system.
And when you're talking about juvenile offenders, you're talking about people not who are necessarily bad people intent on doing bad things for the rest of their lives, but the crime results from a lot of social and economic factors. So trying to fix that problem by locking kids up is like trying to fix a hole in a boat by fetching more buckets. I mean, it's a back-end solution that doesn't work. You have to address the problem. And there's no silver bullet that's going to address it. But Sean and Julie mentioned programs like Prodigy and Boys and Girls Club. You take the Boys and Girls Clubs here, which the law enforcement community and the criminal justice community strongly supports. They have like a 98% success ratio in keeping kids out of the criminal justice system for at-risk youths. It's cost-effective. It's criminal justice effective. We need to put resources in the front end to fix the hole in the boat rather than buying more buckets.
My suggestion is to be very proactive in having children succeed, especially poor minority children. I'd like to see more specialized attention and services in the public school system. We know they're more likely to be held back, to be suspended or expelled. In addition, academic assistance for children, teachers should be trained in implicit bias, school and social service programs to help both struggling children and their parents should be in place, and public schools, social workers, teachers need to be better funded. In foster care, the same thing. There's a huge increase in the number of children entering foster care. When they come in with the trauma they've experienced and it's not treated appropriately, the placements, they disrupt and then they run. They're out on the street. So we need specialized placements where they can have wraparound services. The last thing I would say is guns. The direct file statute, a lot of mandatory direct files if there's a gun involved. We have too many guns on the street. They're very accessible even to poor children. How about buyback programs of guns? How about something like that? That has worked in other communities, and I think that should be funded.
So what we've been focusing on right now is reform, and in order to, in Florida at least, to push reform on this issue, it seems that we need a bill to do so. Sean, you filed HB 509 that, as you said, did not go anywhere. What was its actual intent, and what parts of the bill did you know would be the hardest to get consensus on?
Thanks. You know, the biggest thing was that it eliminated mandatory direct file, but I knew, and I think I spoke to Andrew about this when I originally filed the bill, any encroachment or perceived encroachment on discretion always gets a lot of pushback in Tallahassee. So, you know, this is one of those things that maybe you move the ball a little bit each year and we get something done, but I would tell you that it was just very disappointing, the entire lack of criminal justice reform, period, because when session first started, this session, Republicans and Democrats, we were having all these kumbaya press conferences, and we were going to have all this reform, and this was the year, and yada, 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 and none of it happened. And that was very frustrating. Again, here in Hillsborough County, we're lucky. We have people in the state attorney's office and the public defender's office who are doing everything they can under the current parameters to institute reform. But you know, this bill would have modified the age in which a child can be prosecuted, would have allowed a child to request a hearing before a court to determine if his or her case should remain in adult court. There were a lot of good things in the bill. I thought it was some common sense kind of compromise stuff in the bill, but unfortunately, it did not get one hearing. And what that tells you is, it's one thing if the bill got a few hearings and then died. If the bill didn't get a hearing at all, I think that tells you that someone or somebody has zero appetite for this type of reform.
So you mentioned moving the ball this past session, but if certain things are off the table, how do you?
Well, the Senate moved it in two committees, and we have elections coming up. And so there's going to be a sea change of people in the legislature, in the Senate, in the House, and in the cabinet. And so you maybe have a different set of leadership who want to go forward on this. And you know, elections matter, and who you send up to Tallahassee matters when it comes to these things. And you know, we all, you know, I represent the urban core of Tampa. So I represent, I have a majority-minority district, and so anytime that I went anywhere, this was an issue that came up. The school-to-prison pipeline was referenced. This is an important issue. Someone else talked about the schools. There was a study, I think, a few years ago that in Hillsborough County, children of color were disproportionately punished, and punished more severely than their white counterparts. There's a direct correlation between that and then the subsequent interaction with the criminal justice system. All of those things you have to take into account, and they're complicated. But we have to address it. We all know what the problems are. We just have to have the appetite to do it. We did not have the appetite this year. I hope elections change that appetite.
Prosecutorial discretion has continued to come up, and it was part of HB 509. Andrew, what parts of 509 would you be willing to accept from your perspective, and then what type of direct file reform bill would you support?
I'm sitting right here.
Yes, we are.
Well, I don't think I should have to answer the questions because the bill died in committee. You know, Sean commented on the data tracking part. I'll start with that. I actually think the data tracking is a good thing. I don't disagree that we have lots of data out there in terms of policies and programs that work. We do need better data collection in the state of Florida, just in terms of how we're charging kids, what the outcomes is to adults as well. The core part of 509 was judicial oversight of direct filing. I believe strongly in prosecutorial discretion, but I don't have a problem with a judicial check. I mean, the legislature has codified where we can exercise our discretion and where I'm mandated to exercise my discretion. I'm not even sure how that makes any sense. We have the mandatory file with discretion. But essentially, we have discretion about all direct files. And I have no problem with a judicial check on that. I think that's a way to ensure that state attorneys are doing what the legislature intended us to do.
I'm just surprised by that comment because
Well,
it
I mean,
seems like there's.
I told you we're lucky here. Like we have officials in the criminal justice area who are progressive and all agree. I mean, I run these things by public defender and state attorney, but I didn't file this and to say, Andrew, watch this. I mean, we all kind of talked before I filed this. I wouldn't file something unless I ran it by the two experts on the ground.
You know, I think it's important for us to recognize that the judicial waiver, if that is what the judicial check means, what that would allow is the judges that have chosen, for instance, in Hillsborough County, to intentionally get themselves assigned to the juvenile delinquency divisions. Those are people who really have an interest in children and would be willing to take the heat, for no other way of describing it. They'd be willing to take the heat of saying, no, I'm not going to put this person into the adult system. I'm going to keep them here in the juvenile justice system. So if that's what we're talking about, I mean, I think that would be great progress if we could do that. Anything that's mandatory, I agree with Andrew. I mean, he has discretion, period. But what's interesting is when the legislature is mandating who shall be direct file, they're totally ignoring individualized attention to children. That's what they're totally ignoring. It becomes then just a cookie cutter type of approach that no matter who you are, no matter where you come from, no matter what your life has been all about, you're going to go into the adult system. And so elimination of the mandatory direct file to me would be significant progress if you're going to keep direct file, because obviously, our position is abolish it, period. But I think the other thing for us to take into consideration is that I don't know if Sean agrees with me on this, but go back and look at the legislative committee meetings and see who stood up against doing the juvenile justice reform, and take seriously what is happening, because we have a sheriff here in Hillsborough County, we have a sheriff right across the bay that are progressive, that are willing to make some changes in terms of how we deal with the criminal justice system. But it's amazing to see who the spokespersons are up there quite often and how they speak, and basically what it is don't take away from me the ability to do what I want to do. Me, period. It's all about, so they refuse to look at the system as a whole. They refuse to look at the consequences of what they have done with the previous law. And so I would encourage you, if Sean was encouraging the same thing, I would encourage you to really pay close attention to this legislative process, because he didn't even get a hearing, but the two hearings that did occur, you can tell why it didn't go anywhere. You can just see who's speaking out against it tremendously.
Rosemary, as the solo non-elected official on this panel, how do you hold all of them accountable for what they're promising and what they say and what they don't do? And what could advocates do better?
Well, I want to say one thing first. When I talked about the solitary confinement, I believe there may be some people here from the sheriff's office. And if so, I just want to tell you, I've been working with them or talking to them, and they have said to me that there will be some meaningful changes made to the solitary confinement. So I just want to put that out there, because I somehow had a feeling you two were the ones I talked to. Anyway, so I want to say that. So I'm very, very happy about that. Very happy about that. But I do want to say, tell me exactly what your question was again.
As an advocate, how do you hold public officials accountable for what they do and don't do? And then how could advocates be stronger in their arguments?
Okay. I think that because we have so many attorneys, and we have some very powerful attorneys who are our crossroads attorneys, this has been such an eye-opener to them, especially about direct files. And I think that there's an education issue that needs to be done, because these people are now for reform, and I think that they will talk about it. I think they will try to hold the feet to the fire of our elected officials. But there's one thing, Andrew, I would like to ask you, and we touched on this at the beginning, as an elected official. at 77% of the children who were direct filed last year in Hillsborough County, 77% of them were black. And that is the second highest figure. I think that was at 100, that would mean 105, and the only one that was higher was 82% in Circuit 2, and I think that was only a handful of kids because it's a very small circuit. So that does bother me. I remember years ago being at the detention center, and a kid that I was seeing there, a client, was telling me that he had 2 cousins there, and I knew his father had been in jail. What we don't want is these kids to feel that this is the norm and not see that there are other options, you know. So I think education's important, but I also think that we should try very hard not to disproportionately affect with direct files minority children. And so Andrew, what do you say to that?
Well, one, I'd be curious I didn't know that statistic, so thank you for providing it. I'd be curious to see what the statistic was in years prior, but either way, okay.
It's just a DJJ, this is all public DJJ information, and the stats are and proportions in the past 5 years.
So we right now are partnering with USF, with the University of South Florida, to actually come in and look at our data with regard to direct files to help us identify blind spots. Because if there is something that we're doing that is leading to disparate outcomes, we want to know about it. Obviously, it's not something that's intentional, but sometimes it's hard for the people making those decisions to identify blind spots in their own process, which is why we've opened up our books to partner with researchers to come in and help us identify those blind spots and fix them.
It actually was 77% the year before too, but that was probably before you came in. That would be 2015, 2016.
Let's continue on with what your office is doing to kind of represent this downward trend. I can go back to the fiscal years from 2012 on to the latest information, and there has been, as I mentioned in the intro, a drop in direct file in your circuit. So what accounts for that downward trend, and what else has changed? You said you're partnering with USF. What else has changed in your office to determine direct file?
Well, from 2013 to 2016, these are calendar year numbers. We were averaging about 150 cases a year. In 2017, we were right at 100. The question was, what changed? The answer is, I got elected. It's the truth. We came in, and from day one, this wasn't a priority for us because we had been an outlier in direct files for 20 years in Hillsborough County, one of the worst in the state. People talk about, and I mentioned this at the beginning, that, to Sean's point, when the James Madison Institute and Southern Poverty Law Center, thank you, are agreeing that direct files should be reserved for the worst of the worst offenders, it's easy to say. When you look at the data, burglary and property crimes made up a plurality of charges of direct files in Hillsborough County. We've reduced that significantly. We are focused on violent and repeat offenders, and that's how the numbers have come down so much.
Julie, are there any trends that haven't changed? What are you still concerned about, besides the abolishment of the whole process?
No, I think you heard what Rosemary said, and I think if you look at the majority of the direct files that Mr. Warren has just referenced, there was a weapon involved, and that is a huge concern. The study that I indicated to you that I just did in the detention center, when Rosemary says there's too many guns on the street, the access to the guns, it was about 88% of the kids in detention said they knew right where they could go to get a gun without money. That's a significant problem. But it is something that coincidentally, I told Andrew about maybe 10 days ago, during the time period that he was in the election process, we had a meeting with law enforcement where the public defender's office was there, state attorney's office, and then law enforcement was also there, primarily led by TPD, Tampa Police Department, because we were concerned with the number of violent crimes that were occurring in the inner city. So we just flat said, what can we do about going out and getting guns away? And so I think Andrew has indicated to me that he intends to try and pursue that subject matter with the Tampa Police Department. And it's gonna, when you ask, how can you hold us accountable? We're all here telling you guns is a problem. I think if we don't do anything between now and when we're running for election in 2020 in an effort to try and change the gun situation, I think that's something that we'll have to live with at that time. We're both on a committee together on a collaborative effort with the Sheriff's Office and other law enforcement called Safe and Sound Hillsborough, where the focus is what can we do about youth violence here in Hillsborough County? What can we do from the prevention standpoint, from the education standpoint, and how can we try and influence policymakers? And Andrew himself comes to those council meetings and is actively involved in it, and it's all focused on the fact that we know how many of the crimes are being committed with guns and the long-term impact that everything has. But kids don't realize when they use the gun what the risk is. They just don't, and you're saying, how can they not? You know, when you go talk to children and they're sitting in the detention center and they go, so do you think I'm gonna be able to go home soon? And they're charged with an aggravated battery with a gun and they've shot somebody and you're thinking, that's probably gonna be an attempted homicide. I mean, but they'll ask you, when do you think I'm gonna be able to go home? And it's a serious question in their mind. That just tells you the challenges that we have. But I think that if we make a concerted effort in Hillsborough County, with or without reform, to change the access to guns in this community, I think we can all walk away from our respective jobs saying we did something that mattered.
And this is probably another panel, but I've heard guns mentioned a few times, and I totally agree that the prevalence of guns on our streets is a massive problem that has a whole lot of consequences, and it's something that this legislature, I definitely don't think is going to do anything more than what we've already done, unfortunately. And I would argue we did not do enough, but that's another panel. But we really need to understand that the gun is the common denominator in a lot of these problems. And the more that we act cute and try to say that there's other things going on, the more we're doing a disservice. It is the gun and the easy access to the gun and the type of gun that you have easy access to, the lack of a background check to be able to purchase that nasty gun. These are things that I think we need to address, and it would have good consequences if we were able to do that.
Now that I'm older and I have older children and I see law enforcement around the court system and out patrolling, et cetera, and I see these young faces, I think of my children. I see my children in their faces, and I think with the availability of guns, it must be very scary for them too. So we do need to get rid of the guns. And I just want to tell a quick experience I had a few years ago in delinquency court, waiting for my hearing to start. And there was a kid who was in middle division, very nerdy looking in a way, and he was charged with bringing a loaded gun to school. It was found in his backpack. I don't know how, but it was found in his backpack. It turns out his mother was totally shocked. He didn't get it from her. She was there. He was getting beat up when he got off the bus. He got a gun. This is a poor kid, good kid. The school was surprised. Everyone's surprised. Too many guns accessible to poor kids, and it makes a huge difference with regard to direct file. It makes a huge difference for law enforcement that's out there.
Sean, you have said a few times that you're lucky to sit between a state attorney and a public defender who collaborate with you. You are now running for statewide office. How do you address justice by geography, and how do you speak to people in the community who say that their children are just the worst in the state?
Well, that doesn't abrogate my desire and my belief that a judge ought to be involved when we're determining who's charged as an adult. That geography doesn't affect that. That's something that I would say to them. And listen, that's why I think the legislature has to do this. You know, they're doing the best they can here with the tools they have. That is why I believe the legislature, as the body who makes laws for the state, needs to get involved here and issue what we believe is the right way to do it, and one way or the other. Obviously, this is the right way, I believe. In fact, I believe it's probably even more towards the public defender, but this was sort of a compromise bill to try to get it somewhere. But the legislature needs to do its job and address this. If we're all gonna talk about how reform is morally the right thing to do, fiscally the right thing to do, then let's address it. I would tell you that the legislature is talking out both sides of its mouth, and when you're talking about being an advocate and getting involved, go to Tallahassee. Visit your representative. See how they vote on some of these things. Ask the chairs of the various committees why this bill wasn't agended, or why another bill that you believe is important wasn't agended. Those are questions that you are entitled to ask. You are a voter, and you are our boss. You should go there and figure out why we're not doing what we say we would, or why we're not doing what you would like us to do, if that's in fact happening.
On the side of reform, legislative reform, if we can't even pass a data collection reform bill, how do we go past data and talk about the children and their needs in the community as opposed to just numbers and expenses and costs? Rosemary.
That's a really deep question. I feel really privileged that I've, this practice that I have has turned into what it has, and really I can help kids. So I really understand and I came from a working poor family. And I had a brother who was always in trouble, and I think about, he was brandishing a knife on a beach in Dade County in 1963, and the judge said to my mother, he needs to go in the service, and he did. Now, what if he had a gun? I mean, in today's day, I think about all these things. So yes, we have to get behind, and that's what, when I meet kids and work with kids and meet them week after week at the jail and scratch the surface, I see these are kids just like my kids, who are born innocent, who have talents, but they're never going to be achieved if they stay in this adult system. It's going to be, probation and community control can be a real trap, and they're back in jail, and the whole thing over and over. So I think it's just a matter of, again, education, and we have to talk about this. We can't be politically correct. We got to talk to people about these things. It's really, really important.
Can I give one quick addendum? I'll give you a blueprint of how to have stuff change. It's the Parkland students. That's the blueprint. The Parkland students. Guns is a harder issue politically than direct file, I would argue. And if those kids were able to do what they did to the legislature and shame us into doing something, I would tell you that's a blueprint to follow if you want to enact change.
And last question before I open it up for discussion, or audience discussion. And I'll go in reverse order because I left you off.
Oh, I get my time.
But you'll each have about a minute to just say, what does criminal justice reform mean when it comes to children tried as adults, and what can attendees take with them to push this in their own communities? What can they take home with them? I'm
going to be very fast. Children should be treated as children. They should not be treated as adults. There's a different set of circumstances that ought to be applied. We should be much more in the rehab business in this state than we are, and I just think we have to push this. This is morally, this is the right thing to do, and we just need to move forward on this and make sure not only in our community they're doing what they can, but you got to come to Tallahassee. This isn't going to change on a statewide level until the legislature does something, and unfortunately, I don't think we're there yet. But you can make us get there.
I agree 100%, and I do think we need to work more in Tallahassee, and I do think that Parkland has given us a template for what to do, and I think we need to do it. And we know, we can see that it can be done. We can see that we're better than just going on and on day after day. We have to believe that, and we have to talk to people. We have to be open to talking to people. These kids need to get back on track if they are direct filed. And so I would ask that the state attorney's office seriously consider, when the public defender suggests that juvenile sanctions should be the penalty if there is a plea or a conviction, that they see that this is an opportunity for the child to get back on track after they've been sitting in a jail maybe for hundreds of days.
Obviously, I agree with everything that both Sean and Rosemary have said. And what I would add to that is that I did spend 6 years as the head of the Public Defender Association, and I went to Tallahassee, and I did everything that I could possibly do. I would tell you the education that Rosemary's talking about. Educate yourself about people that are running for office. Educate yourself about how they've conducted themselves while they're in the legislature or while they've been in some other position. Talk to people that you're getting ready to vote for and ask them, what would you do if you had to make a choice between bringing home $1 million to your hometown or doing the right thing on the Parkland vote, for instance, or on juvenile reform? Find out what these people are really going to do once they get into Tallahassee, because I tell you what, it is hard to do what Andrew and I are doing, because sometimes if there's somebody in the legislature that is hearing what we're saying, they're wondering, what do you mean you're not following the law we passed? And both of us have budgets that they're in charge of. And I've actually spoken against a bill and had somebody pull money out of my budget before I got home from Tallahassee. So when I tell you that what we're doing is the right thing at the right time for the right reasons, I want you to know, feel free to hold us accountable, because that's the way we need to operate because of the hand ties that I think exist.
I mean, our juvenile justice system is an on-ramp to the adult prison system. So we need to do a better job of steering kids away from that path. And we have to be tough on violent juvenile offenders, but we have to be tough in a way that holds them accountable without simply turning our backs on them and hoping and praying when they come back into the community a few years later, they're going to be law-abiding citizens. What we need to do with moderate and low-level offenders is do a much better job of intervening early to make sure that we're not turning those kids into the violent offenders, not only as juveniles, but when they come into that 18 to 24-year-old range, which is the highest criminogenic risk factor for committing violent crimes. So it's about holding kids accountable, doing it in a right way that promotes public safety and doesn't promote that revolving door of criminal justice where we're going to see kids again and again and again until either they age out of committing violent crimes or they do something that gets them locked up for the rest of their lives. Or they die. Thank you.
We'll open it up for audience questions.
So let me just preface my question on the fact that I don't prosecute juveniles, I never defended juveniles, so you might say that my question is subjective, I'll say it's ignorant. But what I heard was that Mr. Warren said your system's antiquated. Representative Shaw's request fell on deaf ears to completely abolish direct file. And what I heard Ms. Holt say, and I think Mr. Warren also say, and this is my question, is there anything within the system as it exists that you could do or ask the legislature to do to change? For instance, the 21 days. I thought I heard you say that the 21 days ends up being a real problem because it doesn't give you enough time to make an assessment. And so I'll conclude my question with, or are you concerned that if you just tinker within the system, that the legislature will then just say that, well, we can do this minor fix or that minor fix, and you're not really addressing the problem? So I know that's a compound question, but since there's no judges here to agree that it isn't, and I don't hear objections, then that's my question.
You know, Matt, the juvenile justice system is based on really 90-day speedy trial, 21 days to make the filing decision. There are a lot of people, I think, in the legislature that believe that the reason that they have to use the adult system is because of that juvenile justice system. But there has never been any suggestion that we should change the juvenile justice system.
Would it be helpful to give you a broader period of time?
Well, the answer would be yes. The answer would be yes, because the 21 days is problematic whether it's the juvenile system or the adult system. Just like filing a death notice in 45 days is problematic because I'm trying to scurry around in 21 days or 45 days to come up with a mitigation packet that is meaningful enough to allow Mr. Warren to make the right decision. So all of these time periods that are put on us, you know, to some extent, yeah, they're extremely difficult to deal with. On the other hand, if you're somebody that's incarcerated whether you're a child or an adult, how long that period is problematic. I think that the lack of appetite, if I had my druthers, you would have a juvenile justice system that recognizes that you have punitive natures to it, but it's rehabilitative also in nature. And you would properly fund the Department of Juvenile Justice and its programs, and you would properly fund in the adult system the Department of Corrections so that they can do the rehabilitation piece. In 25 years, my most frustrating thing is that this year, here's DJJ's policy, here's DOC's policy. We're gonna help offenders, we're gonna be, rehabilitative. And just as you're getting yourself going, all of a sudden, it becomes punitive in nature. There's zero tolerance on everything. It's a very difficult system because it's a pendulum that's always moving. Two things that happened: zero tolerance in the school system impacted the juvenile justice system tremendously, and a couple of tourist deaths that happened in Miami were the other two significant things. We react. Florida legislature seems to react to minor in numbers, not incidents, but in numbers. Just because you have two bad things happen doesn't mean you have to redo an entire system. And that's what I think is the biggest failure of how our community has dealt with crime over the last 25 years that I've been the public defender.
I would just say really quickly, if I was running for reelection and I had 6 bills to file, I think maybe I would take this bill, talk to these two, and say, what's one thing we could take out of here that would really make a difference, and run just that one thing maybe and see what that would do. But that is something that maybe I would do if I was coming back.
I just wanted to speak on the issue of allowing judges an opportunity to be the check once the prosecutor makes the decision. Because in Michigan, in 2011, Nathaniel Abraham was 11 years old and committed a murder with a long-arm shotgun through trees that hit and killed someone. He didn't have a perfect shooting ability, but he killed someone. Back then, in Michigan, there was no direct file, and a judge had the discretion to keep him as a juvenile and sentence him as a juvenile. Because of that case, it was taken away by the legislature. So now, it's purely prosecutorial discretion. So I just implore you, if your bill gets passed, don't leave the judges in a lurch. Continue to work together so that the judges can import a system, a process in evaluating those young juveniles and making their decision with some support from the community. Because as Judge Todd said in the earlier panel, judges run for election and it never fails. People will come out and say, the judge did this and I won't do that when I'm a judge. So, just a word of
I totally agree with you. I've sit here and bashed the legislature as much as I could, being a member of it. I trust your discretion much more than I trust ours to put this all, and so I would rather.
I don't.
Well, I'm just saying, rather than the legislature telling people what to do.
I have a hanging judge. Do I want that judge to look at these kids? I know what this judge has done. I'd be better off with the legislature.
What
Don't-
county? I'm sorry.
The county.
Citrus.
Okay, yeah, you do.
I think what we're talking about is that if you were in a position to have these judicial waiver hearings, to me, as the public defender, I would love the opportunity to be able to put out everything that there is about why this child should not be direct filed, so that it would go through some appellate review process. It doesn't help that day if I lose. But you get to establish your record, which is why I say if we're going to pass a law, we're acting like this is really difficult. Graham Miller already tells us the United States Supreme Court has spoken. They tell you what to take into consideration. Just pass a bill that tells everybody, here's what to consider, and allow. I will be too in 2 years, but but I mean, we're acting like it's a big, oh my gosh, what should we do? We have the perfect blueprint already. Some of us would like it to have gone a little further. Obviously, because of the work you do, that we're trying to extend it to the group that is 19, 20 years old, the 18-year-olds. We're trying to expand it a little bit. But what we're really trying to do is say we need some judicial discretion, because I've got to just tell you, if I'm a judge and all I have to do up there is look at a plea form and a sentencing score sheet and I have no discretion, The same thing in juvenile. I think the taking out of judges from some decision-making process, your county may be problematic, but I'm talking statewide, because I look at it statewide. We've got to interject the judges back into our system.
Well, give me minimum standards at least.
Yeah, I've got you.
Yeah.
We've run out of time for further questions, so please join me in thanking this panel.